the meantime, I received a judgment from Brother Justice J.B. Pardiwala, Jamshed Pardiwala, in a dissent. So then I thought that's an opportunity for me to not deal with the dissent, but sort of again place some few thoughts. So Justice Suryakant has authored an opinion for himself, Justice Sundaresh and Justice Manoj Mishra. Justice Pardiwala has authored an opinion for himself and in dissent. The majority of us have upheld the constitutional validity of Section 6A of the Citizenship Act 1955. Justice Pardiwala has held that Section 6A of the Citizenship Act 1955 is unconstitutional with prospective effect. I'll just read out just a few extracts. The challenge to the constitutional validity of Section 6A gives rise to the following issues. A, whether the grant of citizenships to migrants from Bangladesh to Assam was within the legislative competence of Parliament under Article 11 of the Constitution. B, whether Section 6A of the Citizenship Act adopts unreasonable cutoff dates and singles out the state of Assam, thereby violating Article 14. C, whether Section 6A can be regarded to be violative of Article 355 on the ground that the provision does not curb undocumented immigration, which amounts to external aggression. D, whether Section 6A is violative of Article 29(1) of the Constitution on the ground that Assamese cultural identity is lost as a direct consequence of granting citizenship to migrants from Bangladesh residing in Assam. E, whether Section 6A(3) of the Citizenship Act is unconstitutional on the ground of temporal unreasonableness. And F, whether Section 6A(2) is unconstitutional on the ground that it neither provides a method for implementation nor empowers the executive to implement the provision. Section 6A confers citizenship on those who migrated from Bangladesh to Assam until 24 March 1971. Article 6 and the proviso to Article 7 confer citizenship on a limited class. Section 6A deals with those who are not covered by the constitutional provisions, that is, those who migrated or re-emigrated after 26 July 1949. The provision also covers those who migrated in the period covered by the constitutional provisions, but who are not covered by the substantive stipulations in the provisions. For example, Article 6 does not cover a person who migrated from East Pakistan to Assam after 19 July 1948, but did not apply to register as a citizen before the commencement of the Constitution. Section 6A confers citizenship on such persons. There is a certain degree of overlap between Section 6A and the constitutional provisions. However, that does not amount to an alteration or amendment of the constitutional provisions. This is for the simple reason that Article 6 and the proviso to Article 7 confer citizenship on the commencement of the Constitution. That is, they deal only with who shall be citizens on 26 January 1950. In contrast, Section 6A confers citizenship from 1 January 1966 to those who migrated before that date. Those who migrated between 1 January 66 and 24 March 71 are conferred citizenship upon the completion of 10 years from the date of detection as a foreigner. Thus, Section 6A confers citizenship on a later date to those who are not covered by Articles 6 and 7. Section 6A could be interpreted to alter or amend Articles 6 and 7 only if it conferred citizenship retrospectively as at the commencement of the Constitution, which is not the case. The use of the phrases notwithstanding and shall not derogate from produce different effects. Article 11, when interpreted on the basis of the above analysis, produces the following meaning. A, the legislative competence of Parliament to enact laws related to citizenship is traceable to entry 17 of List 1 and not Article 11. And B, the provisions in Part 2 do not impact or limit the legislative competence of Parliament. Section 6A was included with the object of reducing the influx of migrants to India and dealing with those who had already migrated. The Assam Accord was a political solution to the issue of growing migration, and Section 6A was a legislative solution. Section 6A is one more statutory intervention in the long list of legislation that balances the humanitarian needs of migrants of Indian origin and the impact of such migration on the economic and cultural needs of the Indian states. Parliament, even before the enactment of the Citizenship Amendment Act 1995, has treated migration to the state of Assam as a cause of concern. Previous sections of this judgment trace the enactment of the Immigrants Expulsion from Assam Act 1950 and the IMDT Act, which dealt with the specific problem of undocumented migration to Assam. The central government could have extended the application of the IMDT Act to any other state by a notification. However, No such notification was issued indicating that the immigration to Assam presented the Union with a unique problem in terms of magnitude and impact. Though other states such as West Bengal, 2,216 kilometers, Meghalaya, 443 kilometers, Tripura, 856 kilometers, and Mizoram, 318 kilometers, share a larger border with Bangladesh as compared to Assam, 263 kilometers. The magnitude of influx to Assam and its impact on the cultural and political rights of the Assamese and tribal populations is higher. The data submitted by the petitioners indicates that the total number of immigrants in Assam is approximately 40 lakhs, 57 lakhs in West Bengal, 30,000 in Meghalaya, and 3,25,000 in Tripura. The impact of 40 lakh migrants in Assam may conceivably greater than the impact of 57 lakh in migrants in West Bengal because of Assam's lesser population and land area compared to West Bengal. Thus, the singling out of Assam is based on rational considerations. Similarly, the cutoff date of 25th March 1971 is also rational. Even before the enactment of Section 6A, the IMDT Act defined an illegal immigrant as a person who entered India on or before 25 March 1971 without travel documents. As noted earlier, the IMDT Act was not specific in its application to Assam. The enactment defined the phrase illegal immigrant for all states, though the central government did not extend the provisions of the Act to other states. On 25 March 1971, the Pakistani army launched Operation Searchlight to curb the Bengali nationalist movement in East Pakistan. The migrants before the operation were considered to be migrants of partition towards which India had a liberal policy. Migrants from Bangladesh after the said date were considered to be migrants of war and not partition. Thus, the cutoff date of 25 March 1971 is reasonable. Having held that both the cutoff date and the singling out of Assam is based on rational considerations, the next question is whether the yardsticks have a rational nexus with the object of the provision. The answer is in the affirmative, since the migration from East Pakistan to Assam was in great numbers after the partition of undivided India, and since the migration from East Pakistan after Operation Searchlight would increase, the yardstick has nexus with the object of A, reducing migration, and B, conferring citizenship to migrants of Indian origin. Section 6A would be under-inclusive only when all those who are similarly situated with respect to the object and on the application of the rational yardstick are not included. Similarly, the provision would be over-inclusive only when those who are not similarly situated with respect to these two parameters are included. That not being the case, Section 6A is neither under-inclusive nor over-inclusive. Article 355 casts a duty on the Union of India to A, protect every state against external aggression, B, protect every state against internal disturbance, and C, ensure that the government of every state is carried out in accordance with the provisions of the Constitution. All these three phrases feature in Part 18 of the Constitution, which deals with emergency powers. If the duty of the Union to safeguard states against external aggression is justiciable in view of Article 355, then petitions could be filed claiming that the Union has not appropriately dealt with any of the situations referred to in Article 355. It could also be contended that emergency powers ought to have been invoked by the Union to deal with the situations appropriately. Reading the duty in Article 355 into a right would effectively place the emergency powers with citizens and courts. Such a consequence would be catastrophic for the federal structure of the Indian Constitution and would subjugate the constitutional status of states. Article 355 cannot be elevated as an independent ground of judicial review in view of the purpose of the provision as a justification clause and the impact of such a reading on the federal framework of the Constitution. As a matter of constitutional principle, the mere presence of different ethnic groups in a state is not sufficient to infringe the right guaranteed by Article 29(1). Article 29(1) confers the right to conserve, which means the right to take positive steps to protect culture and language. The petitioners ought to prove that the necessary effect of the law that promotes the presence of various ethnic groups in a state is that another ethnic group is unable to take steps to protect their culture or language. The petitioner also ought to prove that the inability to take steps to conserve culture or language is attributable to the mere presence of different groups. The detection of the foreigner is an elaborate process that required the state to build manpower and infrastructure for its implementation. The legislature conferred the state with the duty to implement the provision after it had built sufficient infrastructure for the same. The purpose of Section 6A(3) was to provide a long-term solution to the issue of the large influx of migrants from Bangladesh to Assam. It is true that one of the causes of concern which led to the Assam students' movement and culminated with the Assam Accord was a dilution of the electoral right of those native to Assam because of the inflow of migrants. However, the purpose of Section 6A3 cannot be limited to it. The objective behind the enactment of the Citizenship Amendment Act 1985 was to deal with the larger problem of whether Bangladesh migrants of Indian origin could secure citizenship in India. The objective of the provision must be understood in the backdrop of the Indian policy on post-partition migration and the Assam movement. The principle of temporal unreasonableness cannot be applied to a situation where the classification is still relevant to the objective of the provision. The process of detection and conferring citizenship in Assam is a long drawn-out process spanning many decades. To strike it down due to lapse of time would be to ignore the context and object of the provision. Registration is not the de facto model of securing citizenship in India. The use of the deeming fiction in Section 6A2 obviates the need for registration. The provision does not contemplate a registration regime for persons who fall under this category, similar to Sections 3 and 4 of the Citizenship Act.
However, I have looked into the challenge to the constitutional validity of Section 6A of the Act by addressing myself on the question, I quote, whether the absence of any temporal limits in the scheme of Section 6A of the Citizenship Act has rendered the said provision manifestly arbitrary and thus violative of Article 14 of the Constitution. To put it in other words, whether the afflux of time has rendered Section 6A of the Citizenship Act temporally unreasonable and thus liable to be struck down in consequence of violation of Article 14. My line of reasoning proceeds on the footing that a piece of legislation may be valid at the time of enactment, but there could be a provision which by a flux of time may become temporally unreasonable. That is how I have proceeded to express my views. I have said something about the scheme and mechanism of Section 6A. A close reading of Section 6A reveals that the benefit of citizenship to the immigrants from Bangladesh, as envisaged under the Assam Accord, has been conferred under the said provision in two distinct ways. First, Section 6A, subsection 2 provides that persons of Indian origin who came into Assam from the territories now part of Bangladesh before 1/1/1966 and subsequent to their entry have been ordinarily resident in Assam are deemed to be citizens of India. Secondly, Section 6A, subsection 3 provides that persons of Indian origin who came into Assam from the territories now part of Bangladesh on or after 1/1/1966, but before 25/3/1971, and since then have been ordinarily resident in Assam and subsequently have been detected to be a foreigner, shall be liable to have their names deleted from the electoral rolls for a period of 10 years from the date of their detection. The provision further stipulates that persons belonging to this category will be entitled to get themselves registered as citizens with the appropriate authority as per the prescribed procedure, and the rules only upon detection as a foreigner and upon consequent deletion of their name from the electoral rolls. The rules for giving effect to Section 6A of the Citizenship Act were inserted in the Citizenship Rules 1956, vide the Citizenship Amendment Rules 1986, which were brought into force by the notification dated 15 January 1987. The number of immigrants belonging to the 1966-71 stream and detected as foreigner is significantly smaller in comparison to the approximate number of immigrants who had entered into Assam from Bangladesh between 1/1/1966 and 24/3/1971. This, in my considered opinion, doesn't appear to be solely due to the inadequate implementation of Section 6A, but rather due to the inherent and manifest arbitrariness in the mechanism prescribed under the provision, which I shall elaborate upon in later parts of this judgment. Then on the object sought to be achieved by the prescription of two separate cutoff dates, I shall read some portion. The cutoff date of 1/1/1966 clearly categorizes the immigrants into two discernible and determinable categories. The first category is conferred citizenship by the mechanism prescribed under Section 6A, subsection 2, and the second category is conferred citizenship by the procedure prescribed under Section 6A, subsection 3. Indisputably, Section 6A was enacted to give statutory effect to the political settlement arrived at in the form of Assam Accord. The accord was a result of years of negotiation that took place between the central government, state government, AASU, and AAGSP against illegal immigration, which was led at the forefront by several student-run organizations. Initially, the demand of the protesting students was that the National Register of Citizens prepared in the year 1951 should act as the baseline for detection and deportation of illegal immigrants. However, during the course of negotiations, an understanding was reached that 24/3/1971 would act as the cutoff date for detection and deportation of illegal immigrants. However, to avoid deadlocks and expedite the settlement, a further cutoff date of 1/1/1966 was decided as the cutoff date for disenfranchisement as opposed to deportation of the immigrants belonging to the 1966-71 stream. In other words, the set cutoff date was decided as the baseline for detection of immigrants and their consequent deletion from the electoral rolls. Thus, it appears from an overview of the historical context that the only purpose behind the introduction of an additional cutoff date of 1/1/1966 and the corresponding concept of detection and deletion from the electoral rolls was to assuage the apprehensions of the protesting students. By mandating the deletion of all the immigrants belonging to the 1966-71 stream from the electoral rolls, it was hoped that the effect of wrongful inclusion of immigrants in the electoral rolls on the upcoming elections would be mitigated. However, as discussed in the later paragraphs of this judgment, the object of removal of the immigrants belonging to the 1966-71 stream from the electoral rolls could only be meaningful if it was given effect through an exercise of en masse detection and deletion conducted within a fixed time period. It can be seen from paragraph 62 of this judgment that the protesting leaders in Assam at the relevant point of time were opposed to the conduct of elections to the parliament and state legislature unless and until the names of immigrants were dropped from the electoral rolls. It could be said that Section 6A was a humanitarian and beneficial provision for the immigrants. Sorry. However, to say that the sole object sought to be achieved by Section 6A was to confer benefits on the immigrants alone would amount to taking a reductive view of the historical context in which the provision was enacted. In the aforesaid context, I may only say that if such was the sole object of the provision, then there was no need for the legislature to create two distinct categories of immigrants who were eligible for citizenship. The legislature could have simply conferred deemed citizenship on every immigrant who came into Assam before 24/3/1971 from the date of coming into force of Section 6A. The very fact that the second category of immigrants that is 1966-71, was statutorily created and subjected to undergo a more stringent test of procedure for the purpose of obtaining citizenship would indicate that conferment of citizenship was not the sole object of Section 6A, subsection 3. The object behind insertion of Section 6A, subsection 3 seems to have been to pacify the apprehension of the people of Assam that conferment of citizenship would not have an immediate impact on the then upcoming elections in the state of Assam due to the inclusion of a large number of immigrants. The apprehension was taken care of by the scheme of Section 6A, subsection 3, which provides for the removal of the immigrants belonging to the 1966-1771 stream from the electoral rolls for a period of 10 years from the date of their detection. Section 6A, subsection 3 embodies the approach of the government of the day in finding a middle ground between two competing interests prevailing at that time. On one hand, adopting a humanitarian approach towards the immigrant population in Assam, and on the other, ensuring that large-scale immigration doesn't result into the loss of culture, economy, and the political rights of the people of Assam. While construing the object of enactment of Section 6A, one should not lose sight of an important fact, that Section 6A was enacted to give a statutory avatar to certain clauses of the Assam Accord. The provision thus could be said to have been multifaceted in design and purpose and representative of the interests of all the parties to the negotiation. I am of the view that the intention of the parties while signing the accord should be kept in mind while construing the object of Section 6A of the Citizenship Act. Then I have said on whether the onus of detection of foreigners of the 1966-71 stream lies on the state. From a perusal of Section 6A and the associated rules, it is clear that there is no provision which prescribes or provides for self-declaration / registration or voluntary detection as a foreigner within a given time period for availing the benefit of citizenship by registration under Section 6A, subsection 3. The mechanism of implementation of Section 6A is set into motion with the first step of reference of a suspected foreigner to the foreigners tribunal. As soon as a reference is made to the tribunal, the onus is on the suspected person to either establish that he or she is an Indian citizen or to establish that he or she is an immigrant eligible to avail the benefit available under Section 6A. Once the tribunal holds that the suspected person is a foreigner of the 1966-71 stream of immigrants, then again the onus is on the said person to get registered in accordance with the Citizenship Rules 2009, failing which his or her claim to citizenship would abate. While the statute is clear that the onus completely shifts on the suspected foreigner once a reference is made to the tribunal, it appears to me as illogically unique that a person wanting to avail the benefit of citizenship by registration under Section 6A, subsection 3, has to await identification as a suspicious immigrant and subsequent reference to the tribunal. There is no plausible reason why it should be impermissible for him or her to set the mechanism of Section 6A into motion by voluntarily choosing to get detected as a foreigner of the class specified in Section 6A or to make an application for conferment of citizenship. Further, what stands out as palpably rational in the scheme of Section 6A of the Citizenship Act is that there is no end date after which the benefit of citizenship under Section 6A, subsection 3 cannot be availed. I have dealt in later parts of this judgment as to how this militates against the very purpose of the enactment of Section 6, Capital A, subsection 3. I have now said something on temporal reasonableness. Neither Section 6A nor the rules made thereunder prescribe any outer limit for the completion of detection of all such persons who belong to the 1966-71 stream and are eligible to avail the benefits of Section 6A, subsection 3. The clock only starts to tick once the detection is made by the foreigners' tribunal, and there is no prescription as to the period of time within which the exercise of detection is to be completed from the commencement of Section 6A. The absence of any prescribed time limit for detection of foreigners of the 1966-71 stream has twofold adverse consequences. First, it relieves the state from the burden of effectively identifying, detecting, and deleting from the electoral rolls, in accordance with law, all immigrants of the 1966-71 stream. Secondly, it insensitivizes the immigrants belonging to the 1966-71 stream to continue to remain on the electoral rolls for an indefinite period and only get themselves registered under Section 6A once detected by a competent tribunal. Hence, the manner in which the provision is worded counterserves the very purpose of its enactment, which is the speedy and effective identification of foreigners of the 1966-71 stream, their deletion from the electoral rolls, registration with the registering authority, and conferring of regular citizenship. As submitted on behalf of the petitioners, the open-ended nature of Section 6A, subsection 3 also subserves the legislative intent behind the enactment of the IEAA 1950 and the spirit of the Assam Accord. In the absence of any statutory mandate to do so within a time limit, and there being no temporal limit to the applicability of Section 6A, subsection 3, it follows that any immigrant of the 1966-71 stream whose name figures in the electoral rolls would not voluntarily want to get detected as a foreigner, as upon detection, such immigrant becomes liable to having his or her name struck off from the electoral rolls. It is also required to register with the registering authority within a specified time period, failing which he or she would become liable to deportation. Even otherwise, no person belonging to the aforesaid category would, out of their own volition, get detected as a foreigner due to the inherent subjectivity that is involved in the process of scrutiny and determination of the various conditions as stipulated under Section 6A, subsection 3, that is, date of entry into Assam, ordinarily resident, etc. However, the same degree of reluctance would not have been present on part of the immigrants of the said category if the procedure of conferment of citizenship under Section 6A, subsection 3 was instead a one-time exercise, which was to be mandatorily undertaken in a time-bound manner by anyone who wished to avail the benefit of citizenship under the said provision, and any failure to abide by such time-bound procedure would have resulted into the abatement of their claim to citizenship. Seen thus, the working mechanism of Section 6A, subsection 3 goes against its avowed objective. Upon perusal of the statutory scheme under the Citizenship Act, the Foreigners Act 1946, and other related provisions, it could be seen that the mechanism prescribed for giving effect to Section 6A is imbued with the idea of temporal limitations, and in the absence of temporal limits on the period during which 6A is made applicable, the provision counterserves the object it was enacted with. It could be argued that the principle of temporal unreasonableness cannot be made applicable to a situation where the classification still remains relevant to the object sought to be achieved by the provision. However, as discussed in the foregoing paragraphs, the underlying object behind the creation of two distinct categories of immigrants under Section 6A of the Citizenship Act could have been achieved only if the exercise of detection of the immigrants of the 1966-71 stream and their deletion from the electoral rolls was conducted in an en masse and time-bound manner. However, the same having not been achieved as intended, I find no justification to hold that the classification made between the immigrants of the pre-1966 and 1966-71 streams still remains relevant to the object of Section 6A. To allow Section 6A to continue indefinitely for all times to come would tantamount to taking a reductive and one-sided view of the historical context in which Section 6A came to be enacted, more particularly that Section 6A sought to achieve a delicate balance between two competing interests. In the last, on manifest arbitrariness vis-a-vis temporal unreasonableness, I have said, from a perusal of the scheme of Section 6A, subsection 3, it is evident that the procedure prescribed therein leaves the possibility of differential application on similarly situated persons wide open. From any view of the matter, the way in which the provision is worded doesn't effectively serve either the purpose of granting citizenship to the immigrants belonging to the 1966-71 category, nor does it effectively serve the object of the expeditious deletion of the same category of immigrants from the electoral rolls. On the contrary, as discussed in the foregoing paragraphs, Section 6A, in the absence of any temporal limit to its application with the afflux of time, is rather counter-serving the object with which it was enacted. The mechanism doesn't permit an immigrant of the 1966-71 stream to voluntarily seek citizenship, and such an immigrant has to wait indefinitely for a reference to be made to the Foreigners Tribunal. Similarly, in the absence of any specified date for availing the benefit of citizenship under Section 6A, subsection 3, the object of expeditious deletion of immigrants from the electoral roll is not met. While the test of manifest arbitrariness entails a two-pronged test, which requires that first, there is a reasonable classification based on an intelligible differentia, and secondly, that such classification has a rational nexus with the object sought to be achieved by such classification. The test of temporal unreasonableness, on the other hand, would involve a further examination into whether the aforesaid two-pronged have continued to remain relevant with the passage of time. Thus, the test of temporal unreasonableness would require examining the provision in two different time frames. First, when the provision was enacted, and secondly, when such provision comes to be challenged on the ground of temporal unreasonableness. Even if a provision passes the two-pronged test in the first time frame, it may still fail the test in the subsequent time frame if the afflux of time renders either the classification or the object sought to be achieved by such classification, or both, as arbitrary and thus violative of Article 14 of the Constitution. This could be said to be the third prong in the test of manifest arbitrariness under Article 14, as envisaged by the doctrine of temporal unreasonableness. The conclusion. Section 6A has acquired unconstitutionality with the afflux of time. The afflux of time has brought to light the element of manifest arbitrariness in the scheme of Section 6A, subsection 3, which fails to provide a temporal limit to its applicability. The prescribed mechanism shifts the burden of detection of a foreigner solely on the state, thus counter-serving the very purpose for which the provision was enacted, that is, the expedient detection of immigrants belonging to the 1966-71 stream, their deletion from the electoral rolls, and conferment of de jure citizenship only upon the expiry of 10 years. My learned brother, Justice Suryakant, has acknowledged the fact that despite the enactment of Section 6A, the influx of illegal immigrants into the state of Assam did not abate after 1985. My brother has relied upon the report published by the then governor of Assam in 1998 to underscore that there are hordes of immigrants who have illegally entered Assam and are residing there. However, the ultimate view taken by my lord is that such illegal immigration cannot be attributed to Section 6A, which is limited in its ambit and does not by itself create unabated immigration. As discussed earlier, Section 6A, owing to its inherent problems of absence of temporal limit and the sole onus of detection upon the state, has indeed resulted in the influx and continued presence of illegal immigrants in the state of Assam to this date. On another issue on which I would like to respectfully disagree with my learned brother, Justice Suryakant, pertains to the fundamental premise that Section 6A aligns with the fundamental purpose of Articles 6 and 7 respectively of the Constitution. That is, Section 6A also confers citizenship rights on those affected by the partition of India. However, a careful perusal of Section 6A vis-a-vis Articles 6 and 7 respectively would reveal that despite a few similarities between the two, the crucial difference lies in the fact that in Article 6, the onus of registration for a person seeking citizenship lies on that person and not on the state. Additionally, all those persons who migrated to India from Pakistan after 19th of July 1948 had to make an application before the commencement of the Constitution. The permit system which was introduced as per Article 7 was also brought to an end in 1952, as discussed in the foregoing paragraphs. However, as discussed, both these conditions, that is, the onus of registration as well as the specification of a cutoff date till which such applications would have been made, are absent from the very scheme of Section 6A. Seen in the context of temporal unreasonableness, this glaring absence renders the scheme of Section 6 capital A arbitrary and as a result unconstitutional. For all the foregoing reasons, I have reached to the conclusion that Section 6A of the Citizenship Act deserves to be declared invalid with prospective effect, and the same is accordingly declared so. I summarize my final conclusions as follows. A. Immigrants who migrated before 1/1/1966 and were conferred deemed citizenship on the date of commencement of Section 6A subsection 2, subject to fulfillment of all the conditions mentioned therein, shall remain unaffected. B. Immigrants who migrated between 1/1/1966 and 24/3/1971, both inclusive, and have been granted citizenship after following the due procedure prescribed under Section 6A subsection 3 shall remain unaffected. C. Immigrants who migrated between 1/1/1966 and 24/3/1971, both inclusive, and who have been detected as foreigners and have registered themselves with the registering authority as per the prescribed rules, shall be deemed to be citizens of India for all purposes from the date of expiry of a period of 10 years from the date on which they were detected as foreigners. D. Immigrants who migrated between 1/1/1966 and 24/3/1971, both inclusive, and who have been detected as foreigners but have not registered themselves with the registering authority within the prescribed time limit as per the Citizenship Rules 2009 will no longer be eligible for the benefit of citizenship. E. Immigrants who migrated between 1/1/1966 and 24/3/1971, both inclusive, and whose applications are pending for adjudication before the Foreigners Tribunal, or who have preferred any appeal against any order of such tribunal, which is pending before any court, will continue to be governed by Section 6A, subsection 3, as it stood immediately prior to the pronouncement of this judgment, till their appeals are disposed of. And last, F. From the date of pronouncement of this judgment, all immigrants in the state of Assam shall be dealt with in accordance with the applicable laws, and no benefit under Section 6A shall be available to any such immigrant. To be precise, if someone is apprehended as an illegal immigrant after the pronouncement of this judgment, Section 6, capital A of the Citizenship Act will have no application.